primary pediatrics on Lakeview Road. Day full of children with runny noses, getting their shots, hopefully a sticker or a sucker on the way out. It was anything but an ordinary day. That morning, Karter Ambrose, 2 years old, was rushed in a diaper and a wet t-shirt with a pulse that was rapidly disappearing. He was cold to the touch. The bottoms of his feet were white. His eyes were rolled back in his head. Primary pediatrics did what they could. They're a pediatrician's office. They're not an emergency room. They're not EMS. They perform CPR, life-saving measures for that little toddler until EMS got there. EMS took him to Peach County Atrium, where he was pronounced dead. And Karter had issues breathing. He was on medicine. There was a breathing treatment sometimes that he needed. And at first glance, this looked like a child that succumbed to this breathing issue until the autopsy was performed. The cause of death in this case is blunt force injury to the abdomen, causing a lacerated liver. This is a homicide. No doubt about it. And that weekend, Karter was with his mom, the defendant. And his biological father, Kadeem, who will testify, they're not together anymore. So Mom, the defendant, picked up Karter Friday from daycare. He wasn't injured. He seemed okay. Maybe that evening he said, "My tummy hurts." My tummy hurts. But other than that, there was nothing going on. The daycare people are going to come and want to testify that Karter was fine. There were no injuries to him. And then the next day, Saturday, Karter and the defendant went to the defendant's grandfather's house. And again, he was fine, happy, playing. Typical 2-year-old boy. Then the defendant had Karter by herself until Sunday evening when her new boyfriend, Kianna, arrived. You were going to hear that from that Sunday evening until the day that Karter died, he was having stomach pain. He was throwing up. It wasn't until he went lifeless that anybody did anything to get that little boy any help at all. It would have helped to have called Karter's father, who's a firefighter and works in EMS. But the defendant wouldn't let him speak to his child. Over the phone, wouldn't let him see him via FaceTime, nothing. It is only when Karter is at primary pediatrics and is on death's door that she finally tells Dee, "Get here. Karter's not doing well." According to the medical examiner, whom you will hear from, he had multiple blunt force injuries. And when we say multiple, we don't mean 2 or 3. He had quite a few to his abdomen. He also had injuries to his genitalia, an injury to his head. He had a massive laceration to his liver, as well as an injury to his pancreas. Evidence of repeated blows to this child. You are also going to hear, you're going to hear from two people. One who's retired medical examiner, the other is the former chief medical examiner at the time. And that is the time of death. Excuse me, that is the time with which the injuries can be inflicted, or were inflicted, I should say. 1 to 3 days prior to the death of the child. You're going to hear from them. And that time frame is the time frame this defendant, Kianna Davis, sole access, sole control over this child. Now, one thing you're going to notice, because I've said Kianna Davis, he's not sitting over there. It's Kianna by herself. His charges are still pending. There's no deals with him. All right? They're just separated for the time being. That's it. During this trial, you will have the urge, I suspect, to try to pick who did it. Which one beat it? Did they both beat it? I'm sorry to tell you that I do not have the answer to every question that you are going to have in this trial. But the testimony that you are going to hear is that the beating or beatings that this child sustained were only when the defendant or the defendant's boyfriend or the boyfriend had custody. Sole access to this child. They are parties to each other's crimes. The case is entirely circumstantial. There's no video recording, there's no confession, there's no DNA evidence. But you are going to hear from a number of witnesses. You're also going to observe, see, watch, hear that this defendant had multiple interactions with law enforcement. She had a conversation with law enforcement while waiting outside the apartment as law enforcement executed a search warrant on the apartment, or I should say searched the apartment pursuant to her consent. But there were 3 other statements that she gave to police. And not one time did she point the finger at Kianna. Mother of a child who's been beaten and died of a lacerated liver. She doesn't want to do that. But she talks to people. She comes up with all sorts of stuff. Jumped off the bed or the couch. You're going to hear why that's not how this injury occurred. Had diabetes. Or you're not going to hear much of a reason at all. CPR did it. Handlebars of a bike did it. You could think of a number of issues, but you'll hear GBI experts tell you why this is a homicide and not an accident, not the result of some medical condition. The defendant is absolutely guilty beyond a reasonable doubt of murdering her child. But what is reasonable doubt? Now we're going to come back at the end of this. The judge is actually going to read you a bunch of law. She's going to define reasonable doubt. Right? It's a doubt for which a reason can be given. Right? In the mind of an honest juror seeking the truth. You're going to have a lot of pieces, circumstantial pieces. The biggest of which is these injuries occurred and only this defendant and her boyfriend had access to them. She killed her child. I'm going to prove it to you. The evidence is going to bear it out. Thank you.
Mr. Cruz, there with you?
Please, the court. Mr. Dwayne, Ms. Holland, Ladies and gentlemen of the jury, good afternoon. As has been indicated, we thank you for being here. I think it goes without saying that we are here for some, this is a very, very serious matter. Ms. Davis is here proclaiming her innocence in this matter. As has been read to you, this offense allegedly occurred between the 15th of November of 2020, November the 17th of 2020. Here we are, July the 13th of 2026, more than 5.5 years later. Now, as part of our opening remarks, we are to tell you what we expect evidence to show. And also, it's my responsibility as the attorney for Ms. Davis to point out to you certain things that are important. One thing that lawyers like me are always, and prosecutors also, are always concerned with are timelines. When did certain things happen and at what time? Okay? And it's important for you to keep into consideration whenever you're listening to the evidence in this case and deciding these things. You will, at the end of the case, you will have a copy of the indictment that reflects all these charges that have been mentioned to you. This indictment was returned by the House County Grand Jury on October, or it was returned and filed in the clerk's office October the 18th, 2023, almost 3 years later. So the first thing that comes to mind is why wait 3 years? Okay? And you'll see that the evidence will reflect in this case that this child died on November the 17th of 2020. Okay? That there was an autopsy done on this child soon thereafter by the GBI. But one thing that you'll see is that the autopsy results were not released for almost a year. And you have to wonder why. And maybe the state can clear that up. I don't know. We'll see. You will see that like I say, the autopsy report where the pathologist stated that this was a homicide, but based on a lacerated lip, like I say, was released, was signed off by the coroner, was signed off by the pathologist with the GBI, then signed off by the coroner almost a year later. Okay? So that puts us in 2021, a year later. Okay? And once again, this case was not indicted for 2 more years after that. Why? Those are things that you can take into consideration whenever you're studying this case and listening to the evidence in this case. And we'll hear witnesses in this case. And you know, one thing that I'm certain that Judge Adams brought to your attention today, and at some point in time Judge Lumsden will at the conclusion of this case, is that the burden of proof is always on the government to prove each one of these charges against Ms. Davis beyond a reasonable doubt. In other words, they have to prove each and every essential element of each crime charged beyond a reasonable doubt. Ms. Davis has absolutely no burden in this case. In other words, she can sit there and say nothing, and you can't hold that against her. She may or may not testify. We don't know yet. We don't know what the state's going to put up yet. But at the appropriate time, the judge will instruct you that if she should decide to remain silent, you cannot infer or insinuate or hold that against her in any way. A lot of people say, well, she needs to explain to us what happened. No, she doesn't. She doesn't have to. It's not her burden. She doesn't have to prove to you that her only child died because he fell off a bed or bumped into a table or on the handlebars of his little bicycle, that they're going to show you a picture of him on his bicycle. Or that it was done somewhere else, or who it was done by. You know, you can take into consideration the fact that she is jointly indicted with her then boyfriend, Kianna Davis. As far as I understand, Mr. Benton is going to come in the courtroom and testify. He doesn't have to testify. Now, you know, I mean, the state can give him some sort of immunity, but we'll see where that travels. That the boyfriend is not sitting there with us, but he's going to come in and testify against her. We'll see. Now, like I say, you need to take your evidence from the witness stand. This case, and understand, in my years of coming down here trying cases, and I've tried a lot of murder cases before, good jurors, where the charge of malice murder, and it'll be explained to you later by the judge, malice aforethought, something akin to premeditation or something akin to planning. In other words, someone had malice in their heart. You've heard the term an abandoned and malignant heart. You've heard that before. That's why a murder happened. And in the alternative, the state sometimes will say, well, we think it's a felony murder based on another offense, a predicate offense, if you would, that as a result of that predicate offense results in the death of someone. And the felony murder, the first is cruelty to children in the first degree. And the indictment, of course, says that the baby died, was beaten with an object, the nature of which was unknown to the grand jury. In other words, they don't know how the child died. By what means? It was by a bowling ball or a baseball bat or whatever. Okay? That's for them to prove. And for them to bring their pathologist in here to prove to you. Now, some of you have medical experience. But they have to bring in, the state has to bring in evidence to show some sort of blunt force trauma, if you would. You know, there's also the felony murder charge of aggravated assault. And they don't know how, but they're saying that the injuries to the child resulted as a result of an aggravated assault or a weapon of some sort. You know, they have to prove that. But the difference in this case, I submit to you, in my experience in handling criminal cases, is murder in the second degree. That's different from what you generally hear in cases. That's generally different from, if you've been on grand juries in this county or any other county, you don't get too many murders in the second degree where they're saying that the child died irrespective of malice as a result of some sort of failure or neglect to seek medical attention for the child. And it gets a little complicated here, okay? Now, like I say, I don't know if Ms. Davis is going to testify or not, but you will see that the time that this happened, that she was, she's now 35 years old, she was a school teacher at the time. Teaching classes through the Central Georgia Technical College, where she was teaching classes in conjunction with the Houston County School District, as well as she'd go to Jones County, and that's, she was teaching on the days that this child, there will be testimony about him, his stomach hurting. You'll hear that, okay? You will also hear that this child, he was 2 years and 10 months, Karter was, and that he wasn't even a week old and he was already having problems with breathing and asthma and things of that nature. And you will hear, we expect that you'll hear, from the people that were treating him at this pediatric place, that they treated him, that he was hospitalized, that he's always been a sickly child of some sort, as children are prone to do sometimes. And that at the time that, and of course the father of this child is this Karter Ambrose, and you'll hear from him. And he lived with Miss Davis during that period of time, and they talk about how they, I mean, we expect his testimony will be, assuming he's going to be here. But anyway, we expect that to be that they lived together, and then their relationship busted up, okay? But during their relationship, the decision was made by Miss Davis to move. She moved to this apartment complex off Lakeview Road, which is not even 3 football fields away from this pediatric place, so she can be near her doctors. And there'll be a bunch of people that will come testify, I guess, from the pediatric place that Miss Davis was there often with her child. Okay? And of course, the state would have you believe that that should mean nothing, that she moved where she was living at to be within 300 yards of where the doctor's office was at in case there were problems, because once again, the child, within the week after that child was born, was already in the hospital and exhibited sickly behavior or sickly symptoms throughout his young life. You know, once again, the responsibilities on the state to prove their charges against all these charges, all 7 counts, beyond a reasonable doubt. You'll hear the evidence, and I ask you, and I thank you for being here. Because like I say, I mean, like this happened 5.5 years ago. Miss Davis has been patiently waiting to be sitting in that chair in front of a jury of 12 people plus 2 alternates to show you, to exhibit to you that she is not guilty of any of these charges. You know, I with you am patiently waiting to hear what the witnesses are going to say for the state. As Mr. Dwayne has mentioned to you, this is not a case of, you know, there's 2 types of evidence. There's direct evidence and circumstantial evidence. And Mr. Dwayne has said in his opening remark that there's not any direct testimony, or there's not going to be any direct evidence that this lady or anyone struck the blows that ended up killing the child. Okay? It's circumstantial evidence Okay? In other words, the circumstantial evidence that the state is proposing is that, and of course, the doctors are going to come in here, or the medical people are going to say, well, based on their experience, injuries of this type have to result, or can result, anywhere from 24 to 72 hours before someone dies. Not necessarily. Okay? And once again, it's not for Ms. Davis to have to come in here and point the finger at anybody. Okay? They're trying to prove that she committed these offenses. I submit to you that she did not. And, you know, once again, I don't know how adamant I can be to explain to you her innocence. I don't know how adamant she can be to explain her innocence. This is a long day coming from her, or for her. And, you know, I'll be able to ask questions of witnesses for the state. And, you know, once again, as I mentioned before, if there's anything that I do that upsets you or hold it against me, she has lost her only child. Her only child. Almost 6 years ago. She's not guilty of any of these charges, folks. Not guilty. Thank you. You're on.